Can you see them?
Yeah. Then now we see the slides.
Okay, thank you very much, and good afternoon, everyone. Thank you very much, Attila, for inviting me. I very much regret not being able to physically participate physically in the conference and enjoying the wonderful city of Budapest. My presentation, as you might know, will focus on the implementation of the Consumer Credit Directive number 3 in Italy, namely the Directive 2023/2225 of the European Union. The implementation took place by the legislative decree enacting the legislative decree 212 of 2025, a legislative decree which amended the Banking Act, which is the legislative act which currently collects the whole banking law. Of course, it is not surprising that such implementation has taken place without any substantial discrepancies with the wording of the directive. This is not surprising just because the new directive is a full harmonization directive. However, the directive, as almost all directive, leaves much room to member states for remedies and penalties applicable to infringements of the national provisions adopted pursuant to the directive itself. As regards remedies, member states remain free to maintain or introduce national remedies in the fields which are not covered by harmonized provisions. As regards penalties, member states are allowed to lay down the rules on penalties applicable to infringements of the national provisions adopted pursuant to the directive. I will focus my intervention on the question as to whether the Italian legislator and the extent to which the Italian legislator made use of this discretionary power to introduce contractual remedies and or administrative penalties in case of infringement of the obligations introduced on the creditors by the new directive. In particular, I will concentrate my attention on the information obligations and information failures and the credit worthiness assessment and the new obligations surrounding the credit worthiness assessment. As regards the information duties, the new directive increases the information duties at any single stage of the contractual process and imposes more detailed information duties. In particular, this happens as regards advertising and marketing of credit agreements, general and pre-contractual information. It happens as regards the obligation to give adequate explanations to consumers, which is a newly introduced obligation, which comes from the very well known case law concerning credit agreements indexed to foreign currencies. However, the directive does not clarify what happens if this information is not given. Conversely, there is a precise detrimental effect occurring if the consumer has not received the contractual terms and conditions and the information in accordance with Article 20 and 21 of the directive. As the directive makes clear, in this case, the withdrawal period starts from the day on which the consumer receives the contractual terms and conditions and the information. Therefore, there is a postponement of the starting point of the withdrawal right. The new directive, however, makes clear that in any event, the withdrawal right expires 12 months and 14 days after the conclusion of the credit agreement, unless the information failure is particularly serious as it regards the right of the withdrawal itself. In this case, no limitation period applies to the exercise of the withdrawal period. Of course, postponing the withdrawal period gives consumers the right to terminate the contract after the standard 14-day period starting from the conclusion of the contract. However, this postponement raises the question of whether the measure is actually dissuasive. Neither the directive nor the Italian legislator mentions whether the consumer has to pay accrued interest up to the point at which they exercise the right to withdraw. This would be a space free for national legislators to intervene, as Advocate General Hogan pointed out in a very well-known joint case, as he emphasized that member states would be allowed to provide that the absence of certain mandatory information in the credit agreement may result in the loss of interest on the debt. Conversely, the Italian Banking Act, which has not been amended in this regard by the latest legislative decree, simply states that consumers must repay the loan and pay any accrued interest up to the point of withdrawal without specifying whether this provision applies even where the information is not given according to Article 20 and 21. As regards the creditworthiness assessment, the new directive requires a thorough assessment of the consumer's creditworthiness, and therefore it emphasizes that the assessment has to be quite serious and well made. It further specifies that member states should ensure that the creditor only makes the credit available to the consumer where the result of the creditworthiness assessment indicates that the obligations resulting from the credit agreement are likely to be met in the manner required under the agreement. This means that if the bank refuses credit, it must provide reasoning and supporting documentation. This is certainly true, but again, what happens if the assessment is not adequate? What happens if the bank does not fulfill its obligation? This is even more true in the case that the creditworthiness assessment involves the use of automated processing of personal data. This is an issue that the new directive addresses in a very clear way by introducing the consumer's right to request and obtain from the creditor human intervention, consisting of the right to request and obtain a clear and comprehensible explanation of the assessment, express his or her own point of view, request a review of the assessment of the creditworthiness itself. However, again, no explanation is given regarding the case in which this right is not respected, is violated by the bank. Against this background, the Italian legislator, as any national legislator, would have had ample opportunity to address the shortcomings of the EU legislation by introducing specific remedies for failure to provide information and failure to provide inadequate creditworthiness assessment. Instead, the Italian legislator implemented quite precisely Article 45 of the new directive and decided to reinforce the administrative penalties that can be issued by the Bank of Italy, which is the authority, the public authority monitoring and controlling the banking activity. In particular, the new Article 144 of the Banking Act enumerates the provisions whose infringement may give rise to penalties, and the provisions which are listed under this article include provisions concerning information duties and creditworthy and the obligation, the duty to provide a creditworthiness assessment. Conversely, no new provision, no new private law or contractual measure has been introduced by the new legislation, by the new legislative decree of the end of 2025. This means that the only specific private law or contractual so-called penalty, which is specifically provided for by the Banking Act, is Article 125 bis. This provision was introduced when the previous Consumer Credit Directive, the Consumer Credit Directive number 2 of 2008, was implemented, and states that if the contract does not contain certain essential information, namely the type of contract, the parties to the contract, the total amount of the loan, and the conditions for disbursement and repayment, it is void. This provision, which has not been changed or extended by the new legislative decree, is fully in line with the European Court of Justice case law, and is even reinforced by a specific restitution rule, which is provided for by the same provision, which states that the consumer cannot be required to repay more than the sums used, which means that the consumer is not is discharged from paying the interest accrued during the execution of the void contract. In addition, the consumer has the right to repay the amount due, the capital sum, in installments with the same frequency as provided for in the contract, or failing that, in 36 monthly installments. Conversely, no remedy is provided for in case of lack or inadequacy of the creditworthiness assessment. While as we all know, the European Court of Justice has affirmed that in case of creditworthiness, lack of assessment of creditworthiness, the nullity might be compatible, might be consistent with the directive. Italian case law is quite firm in denying that the nullity is actually applicable if the bank does not fulfill its duty, and is firm in applying the right to damages to consumers, which of course is not quite, how can I say, consumer friendly, which is not a consumer friendly remedy, as the consumer needs to prove the damage they suffer and so on and so forth. To conclude, the implementation of the Consumer Credit Directive, the new Consumer Credit Directive, confirms that the Italian legislator prioritizes and relies more on public than on private enforcement of the directive's rules. It did not take the opportunity presented by the implementation of this directive to improve private enforcement and clarify several issues which remain open to discussion. In particular, the current gaps remain unanswered, and several pressing questions remain unanswered. Notably, despite the growing significance of creditworthiness assessments, the available remedies for consumers in the event of a breach of this duty remain unclear. Thank you very much for your attention, and have a nice conference.